tracts of this biodiversity, there are only islands of that biodiversity protected by its reserve system. So the corridors are very, very important. And as I said, in March 2012, Minister Burke, the Environment Minister for the Australian Government, authorised the release of a draft National Wildlife Corridors Plan that was prepared by an advisory group, a special advisory group. This group was chaired by the Honourable Mr Bob Davis, and it generated this draft plan in a very, very brief period of time, and with quite spectacular results. When this work was first started, there was some concept for just a pilot study or two pilot studies for the concept of establishing corridors in the country. The advisory committee has advised the Minister for the Environment that this should be a whole-of-continent approach. It should also recognise corridors that are being put together and managed for a number of years by many, many community groups. So you see something quite remarkable here, that a corridor of 3,600 kilometres will take you 6 days to drive it across the centre of Australia. Corridors along the east coast, the most biodiverse part of our country on the east coast. On the west, in a biodiversity hotspot, the Gondwana corridor. Tasmania, linking east coast to west coast through the Midlands corridor. And across the northern end of Australia, component parts of a savanna corridor, and potentially in the future, a very, very large corridor. It is an extraordinary development. I think it's leadership for the world and inspiration for the world. It is underpinned by some good and quality thinking, and there are 5 points of action in the draft plan. Some of these may be in the final, some may not, but this is what the draft plan suggested. It suggests a Wildlife Corridors Act. It talked about strategic investment. This is biobanking, this is strategic investment of carbon investments and so on. The foundation stones certainly would be the National Reserve System, and the corridor initiatives will include a new designation of National Wildlife Corridors. They don't exist currently. Nationally recognised wildlife corridors, and certainly at a smaller scale, existing wildlife corridors and smaller scale community and regional corridors. As I said, this is quite breathtakingly different to the previous situation where you had volunteer initiatives. This is the government endorsing this work and moving forward. I can move this on. Thank you. Primary land use, you can see that these corridors actually cut across various tenures, various types of land. You can see the big central Australian corridors overlap with major indigenous areas. These are indigenous lands, some of them are indigenous protected areas. But if it means strategic investments, that's strategic social involvement of remote communities in the caring for country type work that the corridors would inspire. The funding for these corridors, a lot of it is private. There are certainly state government contributions of enormous importance, and the Commonwealth Government's Biodiversity Fund, a fund that's been paid for out of the Clean Energy Act and the Carbon Pollution Reduction Schemes, 980 million Australian dollars. That equals the US dollars to help you with currency. Just under $1 billion being allocated to biodiversity conservation. In the last few months, approximately a third of that is being allocated, and preference is given to those schemes that help achieve greater connectivity conservation. So just to remind you the enormity of this work, and it should be inspiration for many people wishing to do this elsewhere around the planet. Thank you very much.
Thank you, Graham. I'd just like to invite our second group of panellists down into the front row here so that they're up, ready to go. This second session will run a bit more quickly. I've asked this group of presenters, perhaps just in here, this group of presenters are going to work through quickly in a 4-minute snapshot the work that they've been doing to really demonstrate at a practical level. I've asked for a 4-minute presentation from each of them, and then we're going to bring the group and the audience here into the discussion and actually start to be a bit more interactive in terms of our presentations. Sandy?
What you had up was correct.
There we go. I stopped following the technicians trying to refer. Sandy, over to you. Thank you.
But I'm hoping Dan gives me an additional minute because you've stolen one of my minutes. My role this afternoon is in the next 4 minutes to try and address the legal aspects of relevance to promoting connectivity conservation at the national level. A difficult, if not impossible, task. How I sought to achieve this, well, I thought I'll provide you with a sketch of some of the relevant legal tools for promoting connectivity conservation. We've heard that some jurisdictions are starting to develop dedicated laws for promoting connectivity conservation, but the majority are not. This does not, however, mean that in those jurisdictions which are not, there is no potential. Because what one finds in a number of sectoral legislation or sectoral laws, if one refers to it in a more generic sense, are tools inherent in conservation legislation, sustainable use legislation, land use planning legislation, development and control, coastal management, and fiscal and economic legislation. Unfortunately, I do not have the time to discuss these each in detail, but simply to sketch them, to illustrate the many possibilities in the context of conservation, entrenching connectivity in the core objectives and principles underpinning the laws, biodiversity planning, we heard from Barbara, potentially in the context of protected areas, making provision for biodiversity agreements for promoting connectivity both within protected areas and outside of protected areas, listing approaches for listing species and ecosystems, and provision for creating institutions, both formal institutions and voluntary institutions. In the context of sustainable use laws, whether we're dealing with water, forests, soils, minerals, marine living resources, heritage, we could add to that list. One finds similar potentials in the context of objectives, principles, resource planning. One could also create administrative measures for controlling those types of activities which hinder connectivity, permitting attached to environmental management plans or programs, subsidy schemes to promote connectivity measures, resources institutions, once again formal and voluntary. In the context of land use planning, and Barbara referred to the great potential of land use planning for promoting connectivity, we could use the myriad of tools available in future spatial planning to shape the future development of our areas. Practical tools such as zoning, feasibly creating connectivity zones, attached to which would be certain land use rights and obligations. Using subdivision to preclude the undue fragmentation of our landscapes, and potentially the use of environmental overlays, which impose an additional overlay of land use rights, potentially obligations. In the context of development control, we find potential, once again, for the traditional type of tools, like environmental impact assessment and attached to permitting, to regulate those activities which may hinder connectivity. The broader scope, strategic environmental assessment, and increasingly an array of other types of planning tools to inform the decision-making in the environmental impact assessment process, such as environmental management frameworks and the designation of critical biodiversity areas. In the context of coastal management, trying to overlap that divide between the marine and the coastal environment, we see the rise of dedicated coastal management legislation, We can integrate connectivity once again into those objectives and principles, coastal planning, making provision for estuarine management, both in the form of plans and in the form of institutions. Designation of coastal management committees, introducing regulatory mechanisms to provide for coastal planning schemes, coastal setback lines, coastal leases, and an array of enforcement mechanisms. And lastly, in the context of fiscal laws, we could use income tax, property tax, capital gains tax, estate duty, transfer duty to promote the use of connectivity through the grant of incentives and to create disincentives to those types of activities which hinder connectivity. Add to those in the contemporary context, we see the rise of payment for ecosystem services and additional climate financing options. So clearly, if one does not have dedicated connectivity legislation, there are a diverse array of tools inherent in many sectoral laws. I've only introduced a few of those to you. There are many more. And I do encourage you to read the Connectivity Conservation Law Guidelines in the table over there if you wish to unpack these and understand them further. And I'm happy to introduce those to you further in a moment during the discussion. Lastly, planning is an imperative. One needs to draw from the diversity of tools. One needs to tailor those tools to local specificities, adopt a phased approach, and promote cooperative governance as we're dealing with many sectors, many laws, and many institutions. Thank you.
Thank you, Sandy. Great snapshot in 4 minutes of law and the relationship with connectivity. Now I'd like to introduce Elaine. And Elaine's certainly going to give us some insight into the social aspects of connectivity.
Thank you. So my name is Elaine Shaw. I'm a member of the Tulsa Mountain Social Policy Group in Scotch. This was supposed to be Nigel Cromwell. I was going to speak today, but I'm here instead. So the title maybe for this would be something like the social aspects of connectivity, conservation, and the bottom line is someone how to shift to it. So connectivity is more than just about connectivity of landscapes or land to seascapes. It's also about connecting people to land and water, and also about connecting people to people or peoples through land and water. And I've always considered, we talk about connectivity for resilience, and resilience is about more than just ecological resilience, it's also social resilience, and we can't have one or the other without both, essentially. And the other aspect about connectivity that I looked at there is the idea of peace, and international peace between nations, social peace between peoples, and ecological peace between humans and nature. And all of these are interrelated, interdependent, and interconnected. When we look at transboundary protected areas law, especially transboundary protected areas agreements, which have been created essentially ad hoc throughout the world, there is sort of one pattern that can be sort of pulled or drawn from the cases that exist out there. And one thing is that these transboundary protected areas agreements or connectivity agreements are mostly top-down, state-driven structures. There are very few instances where there are indigenous or local communities involved as direct signatories in any of these connectivity agreements. And sometimes there's civil society representation, but usually in the form of large international environmental NGOs. So we need to find ways to include local and indigenous communities, especially because what we're talking about at the landscape or waterscape scale is so complex and involves many different land tenures and rights and collective rights and pluralistic legal systems. And there are many risks and opportunities that can be involved for indigenous and local peoples. So in order to make sure that those risks are conducted and that the opportunities are taken, indigenous and local communities must be present at the table from the very start, representing their own organizations or represented by their own organizations and institutions with the space to speak freely and not be corralled by bureaucratic or scientific interests. So just to give a couple thoughts on how this could sort of be implemented. I mean, my own research has been on peace parks and transboundary protected areas in places of conflict. And at one point I was looking at the idea of patchwork peace parks, and that's what connectivity conservation is today, this idea of trying to, for different parcels of conservation coming together. And in places where you're exploring a new connectivity conservation area. I think one of the most important things is understanding the socio-legal landscape. And that involves looking at the different people that are involved, different stakeholders, their different rights, and the different land tenures, and the different types of conservation that can exist. In the places where there's already an existing transboundary protected area and communities have not been included, the important thing there is to include refined ways to bring that in, to bring stakeholders that have been marginalized. In my work in the Central Albertine Area was looking at the use of actually not the protected areas themselves, but rather the resource of water as a way to bring stakeholders in. So we need to be more innovative in our ways of broadening inclusion. And in all cases, I'd like to put that consultation, or in this case, that's informed consultation, is not necessarily the best standard or the gold standard. Participants are, Indigenous and local communities need to be at consensus from the very beginning, and not just, or involved in the collaborative design, and not just brought a connectivity agreement to agree to afterwards. So as my appeal essentially is that as we're designing connectivity conservation areas and trying to reach our protected areas for targets, is to consider the many social issues, and especially the people that are involved. Thank you.
The line does deserve extra round of applause. I think being called in at short notice as Nigel was unable to present today, so thank you very much, Elaine. Our next presenter, Tanyana, is going to talk on Central Asia aspects of connectivity.